Oh, you may not have known of a person called Brandon Lord before, but now you will realize who he is and how it impacts your wallet and your purse. As the executive director of the Trade Programs Directorate in the Office of Trade at U.S. Customs and Border Protection, that's a mouthful, but he is the officer responsible for arranging reimbursements to American importers now that the U.S. Supreme Court has ruled down Donald Trump's tariffs. And we are not talking about a little endeavor. We are talking about something tremendous. Based on assertions Mr. Lord made, it will take more than 4 million man-hours to handle about 53 million refunds, involving 330,000 importers, totaling more than 166 billion. Judge Eaton, the judge at the Court of International Trade in New York monitoring the refund process, put a stop on immediate payout because Customs and Border Protection has claimed it is not ready to do so swiftly. They argue they do not have the staff, the time, or the administrative ability. Their calculation estimates the return procedure may take years. Whether Judge Eaton permits that and whether the American people accepts it remains to be seen. I'm Michael Popak, and you're on Midas Touch and Legal AF. While you're here, walk over to the Legal AF YouTube channel and press the free subscribe button. Let's speak about the ruling, then the procedure. It is one thing for the U.S. Supreme Court a few weeks ago to pronounce that Donald Trump's tariffs on imports from more than 200 nations were unlawful and unconstitutional under the International Emergency Economic Powers Act. It is another thing completely to untangle what transpired thereafter. The Supreme Court deemed the tariffs unlawful, but the justices are neither economists, company operators, or customs officials. They do not run Customs and Border Protection. They did not have to handle the mechanics of repayment. They deemed the tariffs unconstitutional and left the cleaning to the authorities. That matter then proceeded to the Court of International Trade. The top judge sent the issue to Senior Judge Eaton in New York. Last Monday, Judge Eaton ruled that no more IEPA taxes be levied on imported items and that past levies begin to be reversed. Then Brandon Lord filed a declaration basically claiming Customs requires exemption from the time frame. He also backed attempts to defer payments long beyond the present government. The Treasury Department claims that despite significant war expenditures, including hundreds of billions associated to Iran and tens of billions related to Venezuela, it still has around 600, 700 billion pound available, suggesting the money exists to pay roughly 60 billion owing. But now the problem becomes logistics. Most customs processing is automated by the ACE system, the automated commercial environment. But refunds cannot just be pushed through mechanically. They must be recalculated manually. In paragraph 11 of his statement, Lord stated simply that Customs and Border Protection cannot completely comply with the court's March 4th and March 5 orders to halt applying tariffs and promptly begin refunding them. Why? Because paragraph 17 states they are confronting an unprecedented return volume. He believes that present administrative methods and technology are not designed for work on this scale, and that manual review will draw workers away from vital trade enforcement activities. The stats are staggering. 53 million refund entries, 330,000 importers, 166 billion total. Then paragraph 24 offers the labor estimate. Each refund takes roughly 5 minutes to process after entry screening is complete. Multiply it over 53,173,939 entries, and the result is 4,431,161 man-hours. Customs said it is not practicable to allocate all workers full-time to refunds without jeopardizing other important activities. They even reference a 1998 precedent, United States Shoe Corp. Up vs. United States. That lawsuit included tariff refunds too, but nothing nearly to this size. So this is now the true question. The tariffs were deemed unconstitutional. The money is owing. But can the government possibly repay it quickly? Legally, yes. Administratively, it may become one of the biggest refund operations in contemporary U.S. trade history. And they add that when the Supreme Court threw down export duties in the United States Shoe Corporation case, which involved significantly less money, the refund procedure still took several years, and they anticipate this one will take even longer. So here we are. Money was gathered illegally, and now authorities are claiming it might take 6, 7, or even 8 years to return it. long after Donald Trump is out of office. Now it falls to Judge Eaton and perhaps to Congress to compel a practical solution, since the initial inclination of the administration seems to be delay, stall the process, complicate it, and leave the money sitting where it is. And remember, this is not simply about the principal amount. It is not simply the $160 billion collected via tariffs that must be refunded. There is also interest owing to importers. That interest might add another $10–15 billion, making the total closer to $180 billion. To put it in context, even modest percentage delays on that sort of amount entail significant extra expense. So what happens now? Judge Eaton may need to put the administration under a stringent timeline and need a modernized processing system instead of depending on human entry. Because if refunds continue to be processed one by one, the time frame becomes ludicrous. The obvious option is automation. Reprogram the customs system so refunds may be batch processed rather than manually input. And if manpower is genuinely the problem, then Congress can finance personnel. Let's do the math. 4 million man-hours required. If one full-time worker handles 2,000 hours per year, that equals around 2,000 full-time workers. That is not impossible. Hire 2,000 staff for 1 year and handle the reimbursements. For a federal government that routinely pays emergency administrative activities, this is completely doable if there is political will. Instead of permitting delays to extend over years, the government might approach this like the massive administrative error it is. Because every year delayed means firms continue holding losses from money they never should have paid. At this time, the legal problem is decided. The final struggle is about speed, processes, and political willingness to refund what was unjustly obtained. And that is where Judge Eaton now becomes crucial.